My paper is a bit of the oddball in this panel, in that I'm not going to be talking really about technologies of surveillance or questions of privacy. I'm more interested in talking about how the data that's actually collected from these technologies, and in my case, how the sound and auditory data that are collected from these technologies are used in the courtroom. And I think this is an issue that's going to become even more relevant with the rise of smart devices like Google Home that are heavily voice activated, right? So these technologies in many ways are always listening for those wake words, and in some instances are also recording the kinds of things we say and the kinds of noises we make. So the paper itself is based on a much larger project that I'm doing on sound and law. And one of the things I'm looking at in this project is the use of audio forensic evidence in criminal and civil cases in order to address the following set of questions. First, how does law attend and make sense of sound? More specifically, how do judges hear and deal with audio evidence presented at trial? And what role does hearing play in law and legal decision making? Secondly, how do sound excerpts influence what triers of fact hear at trial? In particular, how do they render sound perceptible and translate raw auditory materials into legal evidence? And lastly, who become the authoritative or expert listeners of sound? And on what grounds have they been able to gain the status of experts? So rather than seeing law as a separate and distinct field from the science and technology of audio forensics, I'm approaching the adversarial setting of the courtroom as a kind of laboratory where scientific facts and technological artifacts can either be legitimized and black boxed or questioned and opened up for further scrutiny. So one specific form of audio forensics that I'm looking at is speaker identification. So this is the practice of linking a speaker to a voice captured on an audio recording by comparing an unknown and known voice exemplar. So in essence, determining the identity of a person based on a voice recording. So in the larger project, I look at a number of different cases in both the US and Canada where the practice of speaker identification has been brought into question. However, for the purposes of today's talk, I want to focus on one specific case that placed audio forensic ID in the spotlight, the murder trial of George Zimmerman. So in particular, I want to essentially recount a story about an audio examiner's unsuccessful attempt at having his expert testimony admitted as evidence, and say a few words about what this case might tell us more generally about law and this particular branch of forensic science. So, just as a bit of background, there are several ways in which audio forensic experts reach their conclusions about the identity of a recorded voice. The most common practice is referred to as oral or spectrographic, as the oral or spectrographic method. This essentially involves the expert listening for key similarities and differences between a forensic or trace recording and a voice recording of a suspect or set of suspects, and running these recordings through a spectrograph to visually compare their spectrograms. Some people have referred to these spectrograms as voice prints, although that's debatable. Now, another technique that's often used is automatic speaker recognition, in which a computer program is used to render a final decision as to whether or not two recordings match. So this technique uses a pre-programmed algorithm to generate speech models of the known and unknown speaker in order to determine the statistical likelihood that the voices captured on the two recordings come from the same individual. So it draws on that same logic used in DNA where it's about probability of identity, not making sort of definitive claims of match, no match. However, while these methods have been around for several years, there's still tremendous debate as to whether or not it's actually possible to match a person's voice to recording. Specifically, there's huge disagreement within the field about whether each voice is truly unique and can produce its own distinctive and stable mark like that of a fingerprint. So a variety of factors, from having a cold to being angry or upset, can drastically alter the nature of one's voice. So as Barnett argues, equating the fingerprint with the voice print fails to appreciate the qualitative differences between the two. Right? That unlike fingerprints, which have a direct tactile relationship to the physical patterns of the skin producing them, spectrographs are only a percussive means of representing the sounds made by the speaker. Hence this debate as to whether or not we should really be using this term voice print. Now, many of the debates about the validity of speaker identification were put under the microscope during the George Zimmerman trial. As most of you in the room know, this is the case where the accused, George Zimmerman, admitted to shooting and killing a young black teenager named Trayvon Martin, but claimed that this was done in self-defense. So one of the key questions here was whether a scream for help captured in the background of a recorded 911 call made by a witness on the night of the shooting, came from the accused or the victim. Now, prior to the trial, two newspapers, the Washington Post and the Orlando Sentinel, had two different experts, called in two different experts to analyze recordings. One of these experts was Tom Owen, who was later called on by the prosecutors to present his findings at trial. So let me tell you a bit about Tom Owen. So Tom Owen is a forensic consultant. He founded a company with his daughter called Owen Forensic Services, based out of New Jersey. He touts that he's provided expert sound evidence in cases involving Mel Gibson, Osama bin Laden, Bruce Springsteen, and Elvis Presley. He's also provided consulting services to TV crime shows such as CSI Las Vegas, CSI Miami, and Law & Order. From 1992 to 2009, he was the instructor for the New York Institute of Forensic Audio, which happens to be a division of his own company, operated out of what appears to be his home, with no official accreditation. So prior to the start of the trial, Tom Owen did several interviews, including one on CNN, got the screen caps there, where he essentially declares with the utmost conviction that the screams for help captured on the 911 call could not have come from George Zimmerman, thus providing further evidence that Zimmerman was the aggressor that evening, not the unarmed martyr. He then explains how a software program called Easy Voice, a program that he happens to market and have a small financial interest in, allowed him to reach his conclusion. So he tells the CNN reporter that a green button appears when the program identifies a match, a yellow one when it's uncertain, and a red one if no match is found. And after comparing a recorded sample of Zimmerman's voice to the scream on the 911 call, a red button popped up, which for Owen automatically meant there was no match. He then reassures the CNN reporter that, quote, "There is nothing subjective about the tests. Quite the opposite. He claims that this comparison was done objectively since it was the computer program that rendered the final decision and not him." So for Owen, the more removed the human is from the analysis, the more objective and accurate the results can be. So to borrow a term from the field of science and technology studies, Owen treats the Easy Voice program as a kind of black box, right? Simply trusts that the technology works and that it produces correct results based on the data that's been entered. So while the CNN reporter doesn't press Mr. Owen to open up this black box and reveal how the software works, Zimmerman's attorneys certainly do. So the defendants filed a motion for a pretrial hearing to determine the admissibility of his testimony and another expert witness hired by the prosecution, Dr. Alan Reich. So the main legal question here was whether or not the methods used by the state's experts to reach their conclusions as to the identity of the person making the screams met the so-called Fry standard. Right? So this case happened in Orlando before the move from Fry to Dobbin standards. So they were still using the older Fry standard. So more specifically, the proponents of the evidence must prove that the testimony is based on a, quote, scientific principle or discovery that is sufficiently established to have gained general acceptance in the particular field in which it belongs. So Zimmerman's attorney sought to have Tom Owen's expert opinion excluded on the grounds that the methods he used were, quote, new and novel, and therefore, quote, not generally accepted by the scientific community. During cross-examination, the defense went on the offensive by first questioning about his credentials and qualifications. We soon learned that Owens holds an undergraduate degree in history, has no formal training in audio forensics or engineering, and that his previous work experience with sound was as a teenager and a young adult when he held various positions in the music and theater industry. Owen was also shown to have exaggerated his previous experience as an expert witness. When first asked by the prosecution, Owen stated that he had worked in the field for over 50 years and that he had testified as an expert witness more than 300 times. Under cross-examination, however, Owens was forced to admit that he had limited experience using the Easy Voice program, and that it turns out that he'd only used the software for a couple of years and has only testified about its use in court once. Now, I think what's more troubling beyond Owen's inability and unwillingness, I think what was even more troubling was Owen's inability and unwillingness to explain how the Easy Voice program worked. When asked by the defense to describe how the software determines a match, Owens seems incapable of doing so. Owens doesn't appear to know the statistical algorithm or even the basic steps that the program uses to analyze voice recordings. When pressed further by the defense, Owen claims that the technology is proprietary, and thus its methodologies can't be made available to the general public. Interestingly, we were told later on in the hearing that This is the main reason why the Easy Voice program has never been peer-reviewed. Yet when Owen does start telling the court about how he analyzed the recordings, things don't get any better for him. During the pretrial hearing, we discover that Owen did not have enough audio data to allow the Easy Voice program to run an analysis. So to deal with this issue, Owen decides to loop the recorded data. So not surprisingly, the defense questions him on his decisions. And once again, Owen shows complete trust that the black box of the Easy Voice program can generate valid findings so long as it's given the necessary amount of data. However, what Owen fails to grasp here is that looping 7 seconds of a sound recording so that it stretches up to 14 seconds doesn't actually give the computer more data to work with. That all it does is give the computer the same auditory data multiple times. And on the screen here is just the transcript of the exchange between Zimmerman's lawyer and Owen. I won't go through all of it, but I just find the first few points quite interesting. So West, Zimmerman's lawyer, asks, well, what was the total duration of those 10 screams? Owen, about 7 seconds. West, I believe you earlier testified that you want 17 seconds, actually that should be 14 seconds of speech for the software to work reliably. Owen, the software would like to see 14 seconds. If you put in 7 seconds, the software says it's not long enough, so I doubled it up. I repeated the same audio twice, back to back, and the program would run the analysis. West, are you aware of studies or research of the software using that method you described where you enter less than enough speech by doubling up? You don't enter less speech by doubling up. You increase the amount of speech. Anyway, bizarre. So there are a number of really interesting issues that came out during the pretrial hearing that I don't have a lot of time to discuss. However, it should come as no surprise to anyone that the judge in this case has just decided to exclude Mr. Owen's testimony from the trial. Judge Nelson explained that the state failed to provide evidence to show that his methods have been tested and found reliable. She notes that while oral perception and spectral analysis are techniques that are generally accepted by the scientific community, their application by the state's witness to the samples from the 911 call was a method that was, quote, new and novel. But while the judge could have easily stopped there, she made it a point to note that the prosecution failed to offer, quote, disinterested or impartial witnesses. So here the judge was alluding to the fact that both of the experts called on the prosecution were testifying in support of their own technologies and techniques. Judge Nelson explained that Owen had an interest in the outcome of this issue because it was his own methodology being tested. More importantly, the judge points out that Owen markets and owns a small financial interest in the Easy Voice program. So in spite of all of his attempts to place the decision-making in the hands of his computer program, Owen was unable to distance himself and his financial interests far enough away from the analysis for it to be deemed objective. However, what's interesting to note here is that the judge doesn't make the same remarks about the defense's expert, Dr. Hirotaki Nakasone. And he's the individual, the examiner, who conducted the FBI's analysis of 911 recordings. And at trial, he testified that no scientist is able to make a conclusion about the identity of the person screaming. And that for a scientist to claim that he or she is able to do so is disturbing given the current state of the technology. So while this may be seen as a rather hostile attack on the credibility of the state's experts, the court did not read the commentary as politically motivated or personally driven. Indeed, the idea that an expert witness can be less than neutral was narrowly defined here. For Judge Nelson, sound experts may be subject to listener bias if they stand to benefit from some type of individual gain. However, experts who defend the status quo and engage in what Thomas Guerin calls boundary work in order to control who's granted entry into their scientific community and what they can claim to do with existing methods and techniques are not seen in the same light. Indeed, there's a failure to recognize that members of a scientific community have a collective interest in ensuring that their science is deemed credible and legitimate, and will also work to maintain the credibility and legitimacy of their field. So just to be clear, I'm not suggesting that the judge made a mistake and that she should have allowed Tom Owen to present his testimony at trial. However, I do think it's problematic to base this decision on an overly simplistic binary of junk science performed by biased scientists driven by personal interest on the one hand, and good science conducted by impartial scientists driven by the benevolent pursuit of knowledge on the other. Indeed, while there's a potential danger in deciding who gets to testify as an expert witness on the basis of there's a potential danger in deciding who gets to testify as an expert witness on the basis of personal interest and underlying motivation. As STS, science and technology scholars have long argued, all scientists have interests, that can never be fully held in check by the simple adoption of the scientific method. This is especially the case when we think about scientists who are brought in to serve as experts within the adversarial system of the courtroom. Moreover, instead of simply interpreting this as a case where a rogue scientist is called out for being a charlatan, we should also see the judge's decision to exclude the evidence as a victory or as a win for the broader community of forensic voice analysts, as it really reaffirmed oral perception and spectrographic analysis as a credible technique, but simply rejected the way it was performed in this particular case. In effect, it was not the general science of forensic speaker identification that was on trial here, but the actions and behavior of an overzealous practitioner. Yet, just as Owen cannot claim that computers and technology can make decisions less human, therefore less subjective, the court should also not fall into a similar trap of assuming that only experts who derive personal gain from offering their opinions are biased and their testimony unscientific and untrustworthy. So just by way of conclusion, I just wanted to highlight one final point that I found of interest here. Interestingly, while the trial judge decided not to allow experts to testify as to who they thought was captured on the 911 call, the judge did allow both parties to play their recording at trial and to call on witnesses familiar with Zimmerman or Martin to state who they thought was screaming for help. So while the court took great effort in ensuring that the methods used by experts to determine the identity of a voice were scientific and credible before they could be entered at trial, it was not all concerned about friends and family members of either the victim or the accused taking the stand and presenting their unscientific opinion as to who they thought was screaming on the tape. Unlike the experts, the court wasn't concerned about these witnesses being too close or personally invested in the outcome of the trial, and that their testimony could be potentially biased. Indeed, the issue of potential bias and lack of objectivity only mattered when it came to the state's experts. And arguably, the judge in this case was less concerned in keeping questionable and unscientific methods of speaker identification out, and more worried and more concerned about granting bad scientists the authoritative status of experts and allowing them in.